All right, there we are. Hi, everybody. John Martin, trial attorney from the KJC Law Firm in Boston and Worcester, and very excited to welcome with me today Peter J. Jameson. How are you, sir?
Doing great, John. How about yourself?
Good, man. Thanks for coming on to answer some questions about family law. We actually had quite a few people respond to my post with questions, which I was really excited about. It sounds like there's a lot of family law issues. Before we get started, why don't you just tell everybody a little bit about yourself, your firm, what do you do, and what you're doing here in the pandemic?
Sure. I'm happy with you. Thanks for asking me to be here. So my name is Pete Jamieson. I do only family law. I work and I'm a partner at a firm called Hastings, Jameson and Lipschutz. We're a family law firm located in North Andover in Essex County, but we practice all over in Essex County, Middlesex, Suffolk, Norfolk County, Nantucket, Worcester. We bounce around a lot. So we specialize all in family law. That's all we do. Predominantly in the probate and family court. There is some overflow into the district court and some of the stuff that we do, but that's mainly in restraining orders. My background is that I started with first clerking with a specific judge in the probate and family court, then doing legal services work, and then ultimately for a while working for the probate and family court itself as a law clerk, writing decisions for the judges and helping them in various areas. And then ultimately went into private practice and been there ever since. And that's what we do. And every week, even though there wasn't a pandemic going on, it's always a lot of work and a very client-centric type of job where we have to focus on what our clients and their specific needs and what they want to accomplish, and approaching it on a case-by-case basis, because not every family is the same and not every solution is the same. But it's not a one-size-fits-all type of approach in family law litigation. But that's what we do.
Yep. Yeah, it seems like a really intense practice, because what's more important in a person's life than their relationship with their children or preserving, their assets and the things that they work for. So it seems like a really intense area of law to practice in.
Yeah, it can be. It can be. I mean, it hits close to home, literally. Our clients, we all say this all the time, because family law attorneys and criminal law attorneys, we seem to be in court the most. And there's an old saying, which is that criminal attorneys find their clients acting at their best behavior. But family law attorneys, we find our clients who are good people, at their worst times in their life, because it's not fun to go through a divorce or go through one of these actions. And we find that, I found in the time that I've done family law, which is now over a decade, is that you got to wear a lot of hats. I'm a litigator, I'm a mediator, I'm always negotiating, always discussing. I'm an investigator, I'm a friend, like all my clients, and sometimes you're a confidant. I mean, you're always a confidant. You have to hear some things and you have to give some advice, but that's the way it goes. But it's a great job, and my clients and my staff and my firm, my partners are all amazing. I find myself to be very, very lucky.
Yeah, so are your clients. We'll jump to the questions in a second, but it just comes to mind one referral I'd sent to you with a very successful father who, turned out to have a pretty serious drinking problem, and I've never seen a lawyer go so far out of their way to help get somebody into rehab and get help and kind of, tape back together that family at he was with me because of a criminal matter, but I think it was, as weird as it sounds, his experience in the family and probate court that, at least for a period of time, got his life in as good a shape as it could be. That was exceptional.
No, and I really appreciate that. That's kind of, we before all this was happening, we were talking about pandemic, and we'll talk about how this had a massive effect on how we do things, and it will have a massive effect into the future. But I mean, it's not strictly a 9-to-5 job. I mean, you got to, family law doesn't occur, events in someone's life, in their family or what affects them, doesn't occur between 8 and 5. It doesn't occur Monday through Fridays. They've gotten calls, Saturday night at 10 o'clock where, we got to deal with the police and take care of things because there's an emergency issue that's happening. So it's just the things that come along with this job. And at the same time, it's what makes it very, very dynamic and very, very fulfilling.
Awesome. So I got some responses. We posted a Facebook post and asked if people had any questions. And for me, for this program that I do, I got an overwhelming response. 9 people had questions.
Sure. Yeah.
Really happy with. Most of them kind of told me a little bit of a narrative. They didn't necessarily know the specific wording of the legal question, and a lot of them are kind of closely related. So I'll just kind of give you, in general, what they told me. The first one is from a female who says that her ex-husband, who's the father of their children, is working as an essential worker with exposure to COVID-19. She does not feel safe with her child visiting with the father. Her lawyer tells her that there's no way to go into court to change custody at this point in time. And she wants to know if there is, if she has to allow the child to visit, and if she doesn't allow the child to visit, what could the consequences for her be?
Sure. So if obviously I won't step on any other attorney's feet. You know, they've never walked a day in my shoes. I haven't walked a day in theirs. But it's important to talk about like where the probate and family court is right now, and that's the court that we deal with in family law issues. It's the probate and family court. There's one in each county. Sometimes there's 2, like in Essex County, that's split between 2 courts. Middlesex, I think there already is 2. I think they've already moved to the second courthouse. But what's important to know is that everything operates on a case-by-case basis. You know, there could be one minor fact that's in one family that is changes the whole narrative for that family than it would be for another family. Just off the top of my head. But what's important to know is that right now, since I think mid-March, maybe March 16th, the probate and family court has been operating under what's called a standing order. And what that means is that right now, only real emergency issues are getting in front of a judge. And that's the thing is that you and the other side, as part of a family law case, can reach any agreement that you want. But the problem is if you don't reach an agreement, and that happens a lot, then the court is the entity that will make that decision. And the issue that we're seeing right now is that given everything that's going on, really primarily emergency cases are getting in front of the judges to make these decisions. That's just what we're seeing. What's an emergency? Well, it's a lot of different things. It's actually listed online in the standing order itself. And that standing order right now, as we know, has been extended to, I believe, June 1st. And there is, a lot of things that make sense. Like if there's an abuse situation or a restraining order, that probably already is covered on the emergency aspects there. Things that are a little bit more on more of the probate side, such as do not resuscitate orders, things of that nature. Those are in there, but there's a lot of other categories. But this category seems to be like the sort of catch-all category with regards to parenting time and danger to the children. And that is very much on a case-by-case basis. Some judges, they haven't specifically, at least as far as I know, haven't stated exactly what an emergency is with regards to parenting time or custody. And it seems to be coming down to a standard where we're talking about the welfare, of course, the best interest of the child, which is the overarching standard that we work with in custodial disputes, and really what's going on that affects the child. And so what I've been saying, and again, I don't know, I haven't spent the time with this client, don't know all the dynamics, and I trust, a good attorney to be giving them the right advice. But what I've been saying is sort of, in my cases, because it was about the first 2 weeks, we really, really got a lot of these questions. Should parenting time happen? Should it occur? We're really concerned that this might be an exposure possibility. Well, a couple things happened. Well, first and foremost, the Chief Justice of the Probate and Family Court, John Casey, issued a letter. And the letter makes it clear that parenting time moves forward. And in fact, the way I read it, I think it even goes even further to say the parenting time right now, given all that's going on, is really, really more important than ever. Because we're all going through so much. I mean, everyone wants to see their kids. And we shouldn't lose contact with our kids during something like this. So, and we've gotten, dribbles and little pieces of what we think is a bit of a standard that could be applied in these types of cases, like a rubric against which the court could intervene and issue orders, but it's varied. But what we're seeing is that definitely this is on a case-by-case basis. Consult with an attorney. And I think what needs to be shown in order to make a change right now to the parenting plan is something that really affects your child, not child A in the sort of theoretic. Your child, direct effect, something that affects their welfare, their safety, their well-being, their best interests, and really puts them at risk.
Gotcha. Next one was exact opposite side of the same equation. This is from a father who says that his child's mother is not letting him see the kids, that there is no risk or change in circumstances. He's apparently spoke to an attorney, or actually asked, the exact questioning is it worth speaking the money to speak to an attorney? He wants to know if he could get into court for that, and if she could be held in contempt for not letting him see his kids.
Yeah, I mean, it's the exact opposite of the side of the coin. I would absolutely recommend speaking to an attorney. I think even if I'm not mistaken, I believe that one of the carve-outs when we talked about emergencies is actually contempt actions where exceptional exigent circumstances have been demonstrated. If I was to look at that, I'd have to see exactly what the angles are in terms of why someone was not allowing parenting time to move forward. I've been when people come to me. First off, I went to law school. I didn't go to medical school. I'm not an epidemiologist. I'm not a doctor specializing in infectious diseases. What I've done when people have come to me and said, "Hey, look, is there an exposure risk here, or are my kids safe?" I say, well, look, what you should be doing is pulling in the pediatrician, speaking to someone with a medical background that can give you specific advice, because that is outside of my purview. I just take the information that an expert gives me and use it in a case. But I think it's very much, definitely speak to an attorney, definitely look like what the risks there, what's present, at least what's being alleged to be present, that someone is saying they shouldn't do parenting time. And move forward on a contempt, because it might fall into that emergency bracket or bucket, I should say, especially in tandem with Chief Justice Casey's letter, where the court's made unequivocal that parenting time should move forward.
That's a fantastic idea about bringing in the pediatrician to assess, to evaluate what is the risk to the child. I never would have thought of that. So these next couple are about child support. One is from a small business owner who says that his business is basically shut down. His income has gone from pretty good to nothing. Can he be held in contempt for not paying child support?
Yeah.
Circumstances.
So here's the overarching piece of advice. Go file a modification now. All right. That's the number one piece of advice I can give to someone that's dealing with the financial loss of income. The main reason for that is I can't say that you're going to get into court anytime soon, because again, as I mentioned, the court's really only is really hearing predominantly emergency hearings, emergency situations. But if you file a complaint for modification specifically, and especially with regards to child support and alimony, then what you've done is you preserved your retroactive rights. So let's say that you've had a massive decrease in your income, and you file a complaint for modification and serve it on May 1, 2020. But let's also say that maybe you don't get heard on a substantive actual hearing on that to decrease your child support until July. Now, there's no guarantees. You never know what's going to happen when you go into court for sure. But if you filed and served it and say that May 1 date, you're giving the court the possibility. The court is then authorized and has the discretion to go back to May 1. So you may not win on May 1, but you're preserving your rights to get relief later on down the road. But if you haven't filed, you don't have that option. And that's why I really, really have been telling everyone that calls me on this issue, file right away, because you'll preserve those rights.
Now, is that something that somebody has to go to the courthouse in person to file?
That's a great question. No. So the court, each county set up some electronic filings and email filings. There's a couple of different ways. There is, depending upon how you approach it and what you're trying to file, there's an e-filing system that the Probate and Family Court has worked out. I know they have it in Essex, I believe also in Middlesex. I'm trying to recall if they have it in each county. I believe there's been email accounts set up for each county in terms of filings. There's also still good old-fashioned mail. It still works. And I believe in some counties still faxes are still going. But there's multiple different ways to get that in there. The other thing, just going back on that, contempt issue, there's no, an order is an order is an order. If there's an order for child support to be paid, the fact that this has happened, or even if someone files a complaint for modification, hasn't changed that order. That order is still in place. So is it possible to be held in contempt? It's possible. That's not entirely impossible. But the point is that there could be a defense there of impossibility of compliance, that your income has taken such a hit and you were living week to week, maybe beforehand, before the pandemic on this issue. But you really need to, in my terms, circle the wagons and really pull together your information, because if you're not able to meet your obligation, you're going to face a contempt. You really should have the documentation to show, to say, hey, look, this is my financial life before the pandemic happened. Here's my financial life now. I'm not saying that that's going to ultimately win the day, but I do think that when this is all said and done, we're going to have a lot of questions about, how do we sort of reconstruct and deal with things in the probate and family court after this is all over? Is this period of time just like a pause button period of time? Is this period of time where we look back on someone who made up, did the best they could with sort of, favorable eyes? I don't know right now, but I do know that if you're facing this issue, file a modification now.
Well, it seems like you're just, posturing yourself in the best possible position too, by being able to show the court, listen, I took it serious. I did the modification. I tried to alert the court as quickly as possible. And, that seems to be a lot better than showing up in June or July or August when the court's open and saying, oops.
Right. Yeah. And that's the other thing is the communication between the parties, Very rarely do I ever tell my clients, don't talk to the other side. Of course, especially when there's kids involved, you want to talk to the other side and make sure that, you have a unified front, you're working together. Mm-hmm. But if, I think there's that old say, it's not what you do, it's how you do it. Mm-hmm. I think take for instance, with payor, if that child support payor reached out to the other side and said, look, if you've read the news, that we're not doing well overall in the economy. Everyone's taking a hit, me included. I really just can't keep up with these child support payments. Can we work something out? Can we do something? And I think that's, even if you do it in tandem with filing a modification, or even if you make that communication before you file, I think that looks pretty good, and it's pretty appealing to the court to say, look, I've tried.
To another child support question, and I'll just read this one out. My ex has been held in contempt multiple times for not paying child support, and his wages were being garnished. He just got laid off and is collecting unemployment plus $600 a week extra. Do I have to do anything for DOR to garnish his unemployment to pay the child support?
Yeah, that's a good question, and I would really consult with the DOR on that one. I would maybe notify them as to that situation. Speak to the local DOR office. I think they have a number that you can give a call to and let them know about that. DOR, they're good people. They have a very, very stressful job, but at the same time on this one as well, even if there's an increase, because that's what it sounded like from that fact pattern, if there was increase in income, again, that doesn't change your child support, at least not in my experience. You would have to still request that modification. But I would notify DOR and see if they can pivot on that one. It may require some kind of hearing or some kind of approach on that one.
Okay. So if the child support payer is going on to unemployment or is collecting these additional benefits under the CARES Act, it's not automatic that the child support will be deducted and paid to the other parent.
That's my assumption, but I would also consult with DOR directly on that. Yeah.
Good. And then this is another tough one, so I'll just read it. My ex-wife and I finalized our divorce in February of this year, and it was read to the court and approved by the court. Since the quarantine started in March, my business has lost a substantial number of revenue. I've just laid off over 10 employees. I'm no longer able to meet my obligations for alimony, and I no longer believe that the asset division was fair. Is it worth paying an attorney to go in and try to renegotiate the deal, or am I stuck with this?
So that's a great question. And I would, for the most part, not in every part, but in the most part, when you would reach an agreement with regards to asset division, that is what we call a surviving provision, meaning that for the most part, you can't modify that. It would take, a significant unforeseen event that just changes the whole nature of the game for there to be a modification of that. Now, that being said, is this pandemic that significant event? I don't know. That's still what we're talking about when we're trying to get past this. The example we say is where you say you have someone that's a successful businessman, and the next day, some awful tragedy like getting hit by a bus occurs, and this person can no longer work, and they need every asset that they have. Does this amount to that level? It very well could be. We're right now, we're in a strange area where we don't have decisive case law in front of us that tells us, like, this is the standard we approach. When we got the Alimony Reform Act back in 2012, we were waiting for about maybe a year or so for decisions to flow through to give us further info that we could work with in interpreting that law. So I anticipate there will be some decisions coming down. It won't be tomorrow, but it will be coming down. With regards to alimony, definitely speak to a lawyer about that, because depending on how the agreement is structured, if the alimony provisions were merging, which means they could potentially be modifiable, then they could maybe be modifiable. But it also depends if it's a business owner. There's some interplay there where we talk about the value of the business and a normalized income in some cases, but we'd have to look at what the structure of the business was, and also really what the effect has been. This whole awful scenario and what we're dealing with. What's the effect on the business and on the overall assets?
All right. Well, those are the basic categories of the questions that we got, and those are really helpful answers. I appreciate you taking the time to do this. Is there anything, for people out there that are experiencing family law issues, or maybe, other family law attorneys, anything that you want to let us know about what's happening with the courts or what's happening with families that, you think would be helpful to us to navigate this unprecedented time in our lives?
Totally. Well, the number one, and this comes from me, from my background, which is that I'm always concerned where we don't have the same levels of avenues to the court as we used to have. And one of my concerns is always domestic violence. I saw a couple of news articles where they said, there's a real risk out there for victims or people that are exposed to domestic violence. Number one thing I would say in such a situation is that you should call the police. The police have protocols in place, and there are avenues in which that if you do need protection from abuse, that they can accomplish that, certainly. And they're still moving forward with restraining orders if you need them, and that's good. That's absolutely what we need in place. Mm-hmm. The other thing is that look, we are in as you mentioned, unprecedented times. I don't know what the court's going to look back on this time with, what kind of viewpoint, but I think that now more than ever, it makes sense that if you have a parenting issue, or it's, a parenting time, or, where the kid's going to go at this stage or that date, well, for the time being, I really would try to work out agreements. There's nothing, on a standard dispute that's not an emergency. I won't be able to get you into court relatively soon. That's just a problem that we're facing. So I am moving towards, trying to resolve things in other ways, trying to reach agreements, looking at alternative dispute resolution, like conciliation or mediation as an option. But, right now it's just, I think for everybody, we should be looking at ways in which resolving it via an agreement, because litigation, I don't think is the answer right now.
Yeah. I mean, trials just are not,
No.
and hearings just are not happening. And,
Yeah.
So I spend most of my time in Superior Court or federal court. Federal's a little bit different, but I can't imagine what the backlog is going to look like when the courthouses open their doors. And I would suspect that in the family and probate court, it's even more of a concern.
Yeah. I mean, there's, we're getting reports and info. And by the way, let me go on the record. I've had a bunch of different Zoom conference calls with bar associations and judges. And I will tell you that they are working as hard as you can possibly imagine to get moving and working through cases and issues. I hold my friends and colleagues in the probate and family court, judges, clerks, court officers, anybody in the highest regard. They're doing all that they can. It's just how can we do this? There's certain restrictions on how many people can, on how they can operate, and they have to look over their own safety as well. So
absolutely,
they are doing everything they can and communicating as much as they can, which has been great. And what we're seeing is that, some cases are shifting over. There's been some telephone conferences. We're hearing that maybe we might be seeing more Zoom hearings, which would be great. And maybe in certain cases, actually, maybe even better than an in-person hearing. But we're in a bit of a holding pattern. But I think that everyone's doing as much as they can on this. Will there be a backlog? We don't know. I mean, what we've been seeing is that the cases that were scheduled, I think beginning March 16th, we've been seeing sort of just a lot of continuances, meaning a rescheduling of the dates. Some of them have been given actual dates, and like in June, July, August, and some of them have just been generally continued. Where I've spoken to people, and it's just sort of like we should be requesting the court for another date when we're through this. So that just underscores, and there may be a backlog, but I know that everyone's working incredibly hard, and just underscores the my previous comment. Look to other ways to get this over with, your dispute over with, because we don't know when we're going to be able to get you back in front of a judge. The hope is the summer. We don't know though.
Well, listen, that was extremely helpful and informative for me, and hopefully it was for some other people who are watching. Thank you so much for your time. I know that you're busy, although it looks like you found a really nice place to hunker down for the quarantine.
Yeah, we're hunkered down. We're good. We're social distancing. We're
beautiful.
All of the above. So things, I wish I was seeing my clients and my friends and my coworkers. But you know what? You make the best of a bad situation.
Yeah, same here. I miss my job. I miss my friends and my hobbies. But I got a vulnerable child at home, so I really appreciate the people who are making the sacrifices in their lives. So thanks for that too, buddy.
Yeah. Well, it's nice. I'll tell you. I was talking about with another friend of mine. I said, it's really nice midday. When my wife and I work in two different offises in our house. It's really nice midday when we meet at 12:30, 1 o'clock. Grab a sandwich. I'll grab a cup of tea. I don't drink coffee. And we get to see each other. I don't get to do that during, before this. And so that's been really, really nice. So always look at the bright side. Some good things are going on right now.
Absolutely, man. You might never have that opportunity again until you're retired.
That's right. Yeah.
All right. Well, listen, thanks again. I really appreciate your time, and looking forward to seeing you in person again someday soon, I hope.
Yeah, John. Yeah, maybe up in Essex County or in Metro West. Okay.
All right. We'll see. That's Framingham, right? Okay. Yeah.